that's true. The way I remember it was that he'd already made one $80,000 bond, and there was some confusion about whether that was to cover all of the cases or just one. But in any event, we had previously, and I believe, presented a agreed motion to the court, and Mr. Henderson had to come in and do a voluntary surrender on the other cases. But as far as I know, what I was thinking was he had an $80,000 bond in one case, and the other two were dropped to a PR bond, was what I remembered. But yeah, he's out on bond on all three cases.
And that is about what I remember too. I will agree to the fact that he made his original $80,000 bond. 2 extra cases were added and indicted, and we did reach an agreement for him to not have those bonds raised or matched to the other 80,000. And he did turn himself in on those warrants, as I recall.
Well, I know I don't think it's going to make much difference one way or the other. The indictment, this may have been reduced by y'all's agreement. There's a $15,000 bond on the indictment in 241057420, and then over here in that may have been reduced to 5,000 by agreement or something. I've just got the docket sheets here and then trying to figure out where we are on it. Over here in 057320, that's a burglary of a building, and the bond on the back of that indictment, when it came out of grand jury, it was $80,000. Some kind of bond reduction hearing or something, Mr. Perkins? Do you know?
And Your Honor, as I'm looking at the paperwork now in Odyssey, I believe that we did in fact file. I'm looking at the motion that we filed for an agreed PR bond at $10,000, and I did sign off on that, and that's in the other 2 cases, 0574 and 0575. Mr. Perkins filed those motions back on May the 27th, and you signed the order on May the 29th.
What did that order say?
It said that the defendant's bond be set as a $5,000 PBO bond with conditions, and that's on both cause numbers 241057420 and 241057520. So that is correct. On those, he has $5,000 bonds. And on the first case, which is 057320, he had previously made an $80,000 bond. And to my knowledge, he has not had any violations of that bond.
I think that is a correct summary because it appears in 2410573. Okay. There was a bond status report I'd gotten way on back in August, but there was no action at this time. Keep me informed. That showed an original bond amount of $80,000. So I think your summation in terms of the bonds on each 3 of the indictments appears to be correct, Ms. Anderson. So let me get back to what y'all said at the start. Are we setting these for trial?
I guess so, Judge, because I conveyed the 10-month offer to Mr. Henderson. He indicated to me that he didn't want to accept that. And so at this point in time, we don't have any plea to announce. And so, I think the only thing to do would be to set it on a trial docket. And I told Mr. Henderson that I don't know when that might be that the case comes to a jury trial, because I anticipate it being, and this might be wishful thinking on my part, but I don't see us having a jury trial, a contested jury trial, for the rest of this year. And even if there are contested jury trials, I would assume that there's going to be a bunch of people in jail that'll be backed up, and that their case would have to be handled first. So I've told Mr. Henderson that I anticipate it probably being sometime next year before his case is ever reached.
All right, I think what we'll do, I think that's a pretty good summary of it, Mr. Perkins, but I think what we'll do is just because of the fact that now y'all, both of you are anticipating a trial. I actually agree with your assessment, and I think most judges and attorneys do. But right now, under the order of the Supreme Court, as we all know, we are not allowed to pull a panel or have a jury trial prior to October 1st, which theoretically leaves the fact that the court's going to have to go ahead and issue trial dockets for October. So just in case, Denise has handed me a setting of October the 19th, 2020 at 10 o'clock, which I'm sure is a trial docket for that date. It looks like 2410573-20, which is the one with the, yes, with the $80,000 affordable bond. Well, it depends on what y'all's position is. I'm sorry to sort of ramble around on it, but 2410575-20. All right, the first one in numerical orders, 2057320. That's the affordable bail bond, $80,000. So we'll set them in numerical order, 0573, 0575 on that trial docket, Mr. Perkins and Ms. Anderson, October the 19th at 2020. Is that a trial docket, Denise?
Yes.
It's a trial docket. So if we need pre-trial longer, I mean, you know, we're obviously going to know the way the orders have been coming out. We're going to know, I would say sometime at the latter part of the first week in September, whether or not the order is going to be pushing jury trials back another month. So once we'll go ahead and set them for that date on the trial docket, October 19th, 2020 at 10 o'clock, Mr. Perkins, with 2410573-20. That is the one on burglary building with that $80,000 affordable bond. It's really all they know to do right now. That'll get them on something where a docket where something will take place on them. Hopefully.
All right. Well, thank you, Your Honor. And just for the record, again, that 10-month offer is now officially withdrawn, and the state will move to stack these offenses.
Yeah, that's the way I understand it. Is that the way you understand it, Mr. Perkins?
It is.
All right. Then if you need latter part of, like I say, first part of September, we should know about trial dockets in October. We're setting it on a trial docket, all three of them in the order by the number. On October the 9th, 2020 at 10 o'clock, you know, if we get down, in other words, if it materializes where we actually think we may go to trial now, it goes without saying, he's out on bond. And I've got, as Ms. Anderson and Mr. Perkins know, a lot of incarcerated defendants who have been there a while, who, if a trial docket's setting that soon, they'll probably be up top, obviously the NGL defendants. But anyway, we'll leave that set and see if we can get something done.
Thank you, Judge.
All right.
Thank you, Your Honor.
You understand all this, you're still under all your conditions of bond. Again, and the main thing is you need to stay in touch, Mr. Henderson, with Mr. Perkins, so he can advise you of what you need to do, because you're continuing on all three bonds, and all three of them are set on that date I just gave. Do you have that date?
Yes, sir.
Okay. You're continued on your bonds, and all your conditions of bonds in all three cases are now set on the trial docket for October 19th, 10 o'clock. It's not anything else. Then it's continued on the bonds, all his conditions of the bonds. Are you reporting on your conditions? I'm sure you are, like stating to your bond supervisor.
Yes, ma'am. Yes, sir. Sorry about that. I actually tested positive for COVID. So the last 2 weeks I've been quarantining.
I'm with you.
And I'm just keeping him updated on my test results until everything is back normal. But as far as that, yes, sir, I've been doing everything I was told.
Okay, I think if you stay in close touch with Mr. Perkins, we'll stay on the right track. There's nothing else.
Yes, sir.
We'll go ahead and be in recess until the only date I have to give you right now, October 19th, 2020 at 10 o'clock. All the state's offers are withdrawn. Anything else? Anything else, Ms. Anderson?
No, Your Honor.
Anything else, Mr. Perkins?
Not on this one, Judge.
We're in recess on these three. Ashley Farmer, boo, looks like Ashley Farmer's on the screen.
Correct.
Well, in cause number 2410192-17, State versus Ashley Farmer, who's present before the court on Zoom with her attorney, Mr. Robert Perkins, and Ms. Anderson, representing the state, is present. All right, what are the announcements on these, Ms. Anderson? What are state's announcement, Ms. Anderson?
Your Honor, there is a first amended motion to, or an amended motion to adjudicate that is currently pending against Ms. Farmer. However, we've released her back in June, I believe, back to her terms and conditions of probation. There's an expert from LifeSafer, which is the company that supplies and operates her interlock device, and we need that expert to be able to testify at the revocation hearing. The state filed a motion for continuance at the last setting in July. The LifeSaver employees are currently not allowed to travel during COVID, and for those restrictions, they're not allowed to make in-person appearances. My office is not proceeding with any experts via Zoom right now because of the fact that they may use data that would not be available to the defense during the hearing. So we are waiting until that expert can travel to proceed on the motion, and Mr. Perkins and I are still discussing the motion. So we're asking the court today for two things. One is that we get a reset date, maybe for late October. That'll give time for the OCA ruling to come out about when jury trials are back in session. I believe that when jury trials start operating again, that's going to influence when LifeSafer allows its employees to travel again for COVID and make court appearances in person. So that's our first request, Your Honor, is for a reset to mid to late October or even the 1st of November.
Well, Mr. Perkins, this would be on then listening to Ms. Anderson in cause number 2410192-17, State versus Ashley Farmer. There's a first amended motion to revoke community supervision. So if I'm following what Ms. Anderson said, she's asking, there's apparently been an agreement to continue the defendant on conditions of bond. Is that?
Conditions of probation, Your Honor.
That's correct, Judge. And we don't have any objection for the purpose of the record. I've talked to Ms. Farmer about the state's motion, the reasons behind that. And what this has allowed us to do is to get a bunch of documentation to the state to look at regarding the defendant's medical condition and whether or not the state decides to eventually have the hearing or not. She's currently on conditions of probation. She understands that those conditions will remain unchanged during this pendency. And we've got a date, a proposed date of October the 27th on the reset form, which we don't object to.
All right, I'm with State Defense Counsels now. So in cause number 2410192-17, the state's first amended motion to revoke community supervision is set for hearing before the court on Tuesday, October the 27th at 1:30. So the defendant has continued on all of her conditions of probation, obviously, which is back on continuing on her probation conditions. She's apparently out on bond, apparently, at least by agreement with the state defense. She, just for the record, is not incarcerated. So she's still on all of her conditions and now of probation. And so the first submitted motion to revoke community supervision filed in 2410192-19, which apparently, I think there's agreed bond on that one, apparently. And so that first submitted motion to revoke community supervision is set for hearing before the court on Tuesday, October 27th at 1:30. Appears to be where we are, Ms. Anderson, Mr. Perkins, is that correct?
That's correct,
Yes,
Judge.
Judge. And Judge, before we recess this case, while we have Mr. Perkins present with Ms. Farmer, I would just ask the court to admonish Ms. Farmer one more time about her conditions. She is subject to both an interlock device on her vehicle and also an in-home scram monitor. And I just want to be sure that she understands that even with, and what Mr. Perkins said is true. He has provided the state with some medical records, and he and I are in discussion about that. But even though we are still in discussions, that does not absolve Ms. Farmer of complying with all the conditions to a T. And that means if she does have a reading that requires a retest, or if she has a scheduled reading, she cannot miss any readings on her scram, scheduled or unscheduled, or retests on her scram device or on her interlock device, or that will result in probation filing a violation report, and that could result in the court issuing a new warrant for her while this is pending. And I just want to make sure that that is very clear.
I've made that clear to her yesterday, Judge, that because of her medical condition, it did not affect her compliance with every term and condition of community supervision. In other words, even if her medical condition would cause her to have a failed test, it was still important for her to take the test.
All right, I understand exactly what both councils are saying. Ms. Farmer, Ms. Ashley Farmer, what I need to ask you is, do you understand what Ms. Anderson and Ms. Perkins have said, with the bottom line being there that you have to follow and comply with all of your bond conditions which relate to your in-home testing device and your interlock device? Do you understand that?
Yes, Your Honor.
Anything?
Thank you,
Yes, Your Honor.
All right. Anything else then? All right.
Not from the state.
Defendant seems to clearly understand she's still under those conditions, has to follow the conditions of probation as to both the in-home interlock device and the interlock device on the vehicle. The in-home's the breathalyzer in the house, and then the interlock device on the car. So Ms. Farmer, understanding all that and understanding those are conditions of probation, if she violates any of those or any other conditions, the state can file a subsequent motion, second amended motion to revoke the community supervision. That cause a warrant to go out. So with that cleared on the record, it appears we're in recess until that October 27th, 1:30 day. Just be sure and continue to report to your supervising probation officer, Ms. Farmer. That's really important. Do you understand that?
Yes, Your Honor.
Anything else, Ms. Anderson?
No, Your Honor.
Mr. Perkins, anything else?
No, Your Honor, thank you.
All right, we're in recess till Tuesday, October 27th at 1:30.
Thank you, Your Honor. May I be excused for the day?
You may be for the day, Ms. Anderson. So can Mr. Perkins, and I'll see Ms. Anderson in the morning.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Mr. Perkins. All right, Mr. All right, we're in recess.